Michaela Leanne Jackson. Could you please come forward? Ms. Jackson, your full name is Michaela Leanne Jackson?
Yes, sir.
How you doing, Ms. Jackson? That's good, Ms. Jackson. You're representing your case by your attorney, Attorney John Macy. Attorney Macy, how are you doing?
I'm fine. Thanks for asking, Judge.
You're welcome. And the state is representing this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, himself.
I'm doing fine. Thanks for asking now. This is cause number 23CCCR 22542. Case is styled the state of Texas versus Michaela Leanne Jackson. Mr. Macy, what is your announcement in Ms. Jackson's case?
Are you doing them individually? Because you've got two. But
The other case is cause number 23CCCR 2266.
yes, Your Honor.
Okay, what is your announcements in both of these
Your
cases?
Honor, I'd ask for a reset. There's some videos that I don't have. And so if I could get a short reset and get an opportunity to get those videos, then we should be able to move forward.
Okay, this is probably your first appearance,
Yes, sir.
first court appearance. Okay, give us a reset date.
July 17th.
Okay, this case is July 17th, 2024. Mr. Macy, once you get your reset, you're free to go.
Thank you.
And you have a blessed day.
Thank you.
Okay.
I can be excused.
Yes, you may be excused. Next case is cause number, get Mr. Castillo. It's cause number 23CCCR 2546 case of state of Texas versus Angel Castillo. Mr. Castillo, you can take your mic off of mute. Take your mic off of mute. Your mic is still on mute. It's still on mute.
Unmute the microphone.
You
O
must-
micrófono está apagado. Goodness.
Well, Mr.
I don't, he's present. but I don't
Gilthar,
think we need
what
to-
is your announcement?
We just need to place him on a trial docket, Judge.
Okay, give us a reset date for trial. Hmm.
Don't.
Mhm.
Judge, the Spanish speaker that you might need a little help. Yeah, the other case, you said that. You might be-
Oh, Orega. Yeah, that his case is just gonna be reset. So they're gonna give him a reset. You could just tell him
Okay.
what his reset date is.
I have to reach for it.
It might already be reset. That's all we're gonna do. Give him his attorney is Mr. Paget. He's has a family emergency. Do you have that reset on Orega? James Paget's client?
I haven't reached. Did you?
Okay, so we're gonna do a reset on Orega.
I'll hang around for a few minutes and I'll see if we.
Okay, and Castillo is a reset for trial.
Correct.
Oh, he must be, he has it off.
Oh, yeah. Yeah, I'm muted.
Can you hear me now? Yes, me.
Yeah, yeah, your, what is this reset date on,
This-
Castillo?
That's gonna be on the trial docket.
Yeah.
Yes,
July 15th.
okay, your case is gonna be reset for trial on July 15th of 2024. Stay in contact with your attorney, stay in contact with your attorney and your bondsman. They will be given notice of your reset. You're free to go. Mr. Castillo, and you have a blessed day.
Thank you, sir.
Okay,
Okay, thank you.
you're welcome. Okay. Mr. Horizon. We could just, I don't think we need to have him to come up.
Is that his name's Rega or Rega?
It's a reg,
I'll just try to make sure we understand.
right here. Sergio
Ariaga.
Arriaga?
Ariaga.
Okay. I see the Reagan. Arriaga. Okay. Arriaga on page 4. Okay. Might as well go ahead on and do oh, okay. Let me do this. Okay. Okay. Next case is cause number 23 CCCR 1888. Case is South State of Texas versus Ryan Paul Barrett. Oh. Let me what date? Hold on. Let me see. Yeah, that's him in the back. Okay. This is cause number 23 CCCR 1888. Case is South State of Texas versus Ryan Paul Barrett. We have Mr. Barrett present in court with his attorney, Attorney Gregory, and we also have the state present with Assistant Attorney Hubel. The court had a bench trial in this case. And I see a trial court certification of defendant's right of appeal, which is dated January 12th of 2024. That was the date that the court found Mr. Barrett guilty. The court did conduct a pre-sentence investigation. Court has received a copy of that pre-sentence investigation. And I think at the hearing that we had a sentencing hearing on February 16th of 2024. If the court did not ask the parties, well, I think the court did ask the parties that they received a copy of the motion, well, a copy of the pre-sentence investigation report. Now, State, is that correct? Did you receive a copy of the pre-sentence investigation report?
At that time, we did, Your Honor.
And do you have any additions, any objections, or do you have any additions or any corrections to?
The second
that
one that I
report?
made at the time that we received them.
Okay, and Mr. Gregory, did you receive a copy of the pre-sentence investigation report?
Yes, Your Honor.
Do you have any objections to or any additions to this pre-sentence investigation report?
I have no additions. I did raise some objections, and I believe the court approved some of those objections back when we had a hearing
Okay,
on that.
okay. And then the court, I guess here, you had to file the motion for reconsideration.
Yes, Your Honor.
Heard that motion, the court denied that motion on February 16th of 2024. And the court reset this case after I think the state put on a complaining witness for some punishment evidence. I don't think there was no other witness that the state put on. Is that correct, State?
Yes, only the complaint witness, Your Honor.
Is that correct, Mr. Record?
That is correct, Your Honor.
Okay, and then the court reset this case for a sentence on today. And so the court has looked at the case, and so I think the court is going to assess punishment in this case.
Your Honor, if I may, I would like to re-urge the motion to reconsideration. You know, this trial was held in the first part of January. You found him guilty on January the 12th. You referenced a February date at which we were here, and the court considered a pre-sentence report. It was reset to March the 27th, at which time we had argument before the court.
Oh, March, okay.
And at that time, the court couldn't sentence him for whatever reason. Let me suggest this. I came across an explanation that says proof beyond a reasonable doubt is the quote hesitate to act formula in Victor v. Nebraska. The United States Supreme Court approved the following version of this formulation. Quote, reasonable doubt is such doubt as would cause a reasonable and prudent person in one of the graver and more important transactions of life to pause and hesitate before taking the represented facts as true and relying thereupon. Judge, that's what you have done in this case. You found him guilty first part of January. And in February, we had a sentencing date, which you put it off into March. And in March, you put it off until now. Here we are 5 whole months later. Judge, you have hesitated and paused the exact definition that the United States Supreme Court said, this is what reasonable doubt is. Judge, you have reasonable doubt in this case.
Okay.
Already ruled.
Now, Mr. Gregory, I'm sure you're aware that Texas does not have a definition for reasonable doubt.
Yes, I do. This is just argument.
Okay.
This is like a jury argument. I'm arguing
Okay.
to the
But I had-
court. I'm suggesting, Judge, you've got reasonable doubt.
Okay, the
There
court-
was that video, there was no mouth movements, there was no audio that this guy said it, what she said he did.
I looked at the video about 30 to 50 times, and I heard the audio that many times. The court made its ruling the next day. He was found guilty the next day. So you saying reasonable doubt, the court made a ruling the next day. The court did not hesitate to find him guilty. He was found guilty the next day. We had trial. Uh-oh.
I just have to keep urging my client's position.
I understand, but that's,
Doing
it's,
what I feel is prudent under my part.
okay,
And I've made my plea one more time.
okay. Well, again, your motion has been denied. The court is going to assess. Oh, yeah, we have that Amber Alert. Okay, so, his punishment is gonna be assessed at 30 days in Jefferson County Jail. However, the court is going to suspend, that, in that jail time, that confinement time, he's gonna be placed on probation for 1 year. During the 1 year probationary period, Mr. Barrett will be, ordered to pay a fine of $300 plus court costs. He, will, be required to, attend and complete the batter's intervention prevention class. He will have a curfew from 10 p.m. to 6 a.m. He cannot have any contact. Now, the curfew will not interfere with his, if his job, it's not going to interfere with his job. Now, he cannot have any contact with the complaining witness in this case, Dalen Thornton. I don't, they asked him for, yeah, he can't have any contact with the complaining witness in this case. And he also will adhere to the other standard terms and conditions of probation.
You are aware that is his ex-wife and they have 2 children together.
I understand, but it won't, let's see. There's no contact, will not interfere with, his, I think they have custody arrangements in a divorce, is that correct?
Now, there's custody action ongoing.
Right, so it shouldn't interfere with that either. I don't know how we can be able to, we should be able to, I think we had a, what we had, he had some bond conditions where we
discussed some wording before.
could probably use that same bond condition.
What you wrote on bond conditions was not the same thing that you verbalized in court, and it didn't get on with bond conditions that there was going to be some contact allowed.
Okay,
with the children.
Oh, okay, let me do this here. Let me look at the bond conditions right quick. Bond. Motion to modify bond conditions. Okay, here we go. Okay, I'm looking at the bond conditions. And it says that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense in a threatening or harassing manner. But I also see that the defendant shall not go near. And I think we put that in there because there's some type of communication that they're allowed to have through the divorce. Is that correct? I think there was some type of
That out.
yeah, some kind of app or something.
Yes, Your Honor.
Okay.
There's a Family Wizard app that they are currently using.
Okay, now, and the other part of the bond condition, the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And I know they have they have 2 children.
Yes,
They
Your
have
Honor.
children who are in school.
Well,
There are
yeah.
times that they have to be at school together.
Well, the alleged victim used your conditions of bond to preclude him from going to school. She took those up to the school and made This thing is all about the child custody thing, you know, I can't
Okay,
say it
okay.
enough times.
Well, what we're gonna do, I mean,
This was retaliation by them because he filed charges on her husband, who was sentenced in this court earlier this year. And it's, another thing, he's the guy who he filed charges against is the
Judge,
same
I'm
one
not
that took that
the fact that
video.
we're getting into like different cases that are
Well,
not.
they're connected, it's all connected. This
Yeah,
is
but
a
I mean-
child custody thing that they've abused your court of bringing this thing in here. He did not threaten the girl.
okay, now, Let's
Let's
see.
see. I'd like for you to change your mind and to quit this thing, Judge. This is.
I mean, the court has already made its ruling.
The court can undo. You're the judge. You can say.
Okay, well, the
you know,
court is not,
we
the
thought
court
this.
has already made its ruling. Okay. So, in reference to, him not going near any residence, school.
Yeah. Well,
Now-
now, let him come up there because she brought that order up. and
Okay,
said,
so we're gonna-
"Well,
I mean, we're gonna-
excluded."
Now, we need to, do you have copies of the order from family court?
Not with me in my.
Okay, I'm just saying that we need we need to draft up something that does not interfere with those court orders. And so what I'm saying, well, at least what I'm suggesting is,
Are you asking our assistant court in some language here?
yeah, I mean, we can, the state as well as the defense can agree on one, what type of contact, because we have that divorce decree and I think, temporary orders out there that allows him to have access to the children.
And in regards to like his inability to go certain places, language that we could possibly put in is outside of appearances that are necessary or customary in the raising of children.
Okay. Okay, so what we need to do is, do you have any objections to that language that he just said? Unless you want to repeat it.
Necessary or customary in the raising of his children.
That he shall not have contact with the victim other than.
Not frequent places. This is we're talking about the frequent places.
Yeah, the frequent place, what the part in this order that says the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And then he was gonna add some language. What was that language?
See,
Unless it's necessary.
necessary and customary in the raising of children, but maybe it'd be better to necessary and customary for in the exercising of his rights under the custody arrangement or something of that nature.
Okay, now we need to have something more specific so that, let's do this here. So what we're going to do, we're just gonna take a few minutes and draft up some language and see if the parties, if that will,
Your Honor, we have someone here from probation that may have a suggestion
Okay.
as to a workable solution.
okay, Mr. Gilliam is a probation officer.
Not completely familiar with the case, but one thing. Leave the wording as is, but then at the end, without prior approval of probation. Then you can come explain what this is gonna be, and we can approve the contact.
But will it be in writing? Because,
We would have to.
You know,
because he would have to have something in writing, because if they go back to the school will be looking at an order prohibiting from, so he has to have something in
You
it.
need it on the original.
Right, we need it on the original probation order. Because that would trump the bond conditions, because once he would, after the day, he would no longer be on bond conditions.
Right.
And so those bond conditions would not be in effect. Okay, so you need a minute to, okay, then what we're gonna do, just have a seat we're gonna work on the language for that portion. Now, let's see. Yeah, well, we didn't, just wait, we still, we'll be in recess on this. We'll come back to it. Sure. Is he here? Yes. You can come on up. Juan Ochoa.
Yes.
The rule does not permit the conduct of frequent license in the gainful customary child and is considered that's the word about. Maybe you just, then you guys are not happy to be.
Okay. Mr. Ochoa, the state is dismissing your cases. I just signed your dismissal. You're gonna get your dismissal from your attorney. Once you get your dismissal, you're free to go. And you have please stand in front of the coordinator. You're welcome. What are we doing? Where's Mom? What are we?
When I saw the one.
With that, that's gonna be laid out in custody.
Yeah.
By that.
Who is Brandon Lumpkin? Was that an add-on?
No, that's not enough.
I have a dismissal on that. Okay, I have a dismissal on that. With Odyssey. And so you dismissing one of Lumpkin's cases? Oh, where's Marcus Wilkerson?
He called, he's not gonna be able to attend.
Okay, Mr. Lumpkin. What, did he leave? So you're gonna reset his other case? Okay, I just signed his dismissal.
Ian Chappie.
Yes. It does say MTRB. Motion to dismiss, motion, okay. Oh, yeah, he's here. Okay, you can come up and get your dismissal. Now, well, why don't you come on up? Mr. Lumpkin, you're representing your case by your attorney Marcus Wilson. He's unable to be here today because of an illness. Your motion to revoke probation has been dismissed by the state. Is that correct, state?
Yes, Your Honor.
And your other case will be reset. Okay. So you're gonna get your reset from you're resetting your dismissal from the court coordinator. Once you get your reset and your dismissal, you're free to go stay in contact with your attorney and your bondsman.
I'm with Eagle.
Oh, okay. Oh,
I'm standing in for Ben.
okay.
Oh, you standing, Mr. Jefferson?
I am Judge. He's standing in for me in Jasper County.
Oh, okay.
I think I got some better.
Oh, well, yeah, the shorter distance.
Yes.
Yeah. Yeah, Sears D. Roberson Jr. Would you please come forward? Would you come forward? And Mr. Roberson, your full name is Sears D. Roberson Jr.?
Yes.
How are you doing, Mr. Roberson? I'm doing fine, thanks for asking, Mr. Roberson. You representing your case by your attorney, Benjamin Jeffries. Attorney Jeffries is unable to be here today. However, standing in for Mr. Jeffries is, let's see, Attorney Tom. You have a note?
No, good.
Okay, Attorney Tom Kelly is standing in for Mr. Jeffries. Does Mr. Kelly have your permission to stand in for Mr. Jeffries? Mr. Kelly, what is your announcement in Mr. Roberson's case?
Judge, my understanding is that there may be a felony case connected to this case that has not been indicted yet.
Okay,
So certainly we're going to need some time to
okay.
figure out what's going on with that.
Oh, well, I see one that says pending felony. Yeah.
I don't know that pending means it's been indicted.
I don't think
yet.
pending
Oh,
is accurate.
oh,
It's been
oh.
received by the state, but it has not yet been.
Well,
indicted.
they got a cause number 23 DCCR 1863.
What is that? Now, this is a different one.
Sometimes they don't have a coordinator.
Yeah, 1863.
Yeah.
Yeah, it's 23 DCCR 1863. That's what they have on the docket sheet.
Hold on.
But in any event, if this is on Sears D. Roberson, we'll reset.
I'm sorry, I apologize. The felony arising from the same incident is only received by the state. It
Oh,
has
that's
been
a different
called-
felony.
I don't see it there.
Hold on,
I'm
we'll
not
just-
sure what
hold
you're
on.
referring to. Can you
That's-
read that out?
I'm looking at
Please hold on.
23 DCCR 1863. That's what's on the docket sheet, Alan.
863 is with.
Yeah, his
Sunny and
initial
Steve.
statement is August 1st. And that is a forgery financial instrument.
That is correct, but that's a separate incident. It's
Different.
from the other felony. That's.
Okay, so we're gonna put this on August, oh, what's that date?
August 1st.
We're gonna reset it on the same date with the other case,
Good.
August 1st. Okay, so this case will be reset. August 1st,
Yes, sir.
2024. Mr. Robertson, you're gonna get your reset from your attorney. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. Mr. Kelly, you don't have any other cases. You're free to go as well and you have a blessed day.
You too, sir.
Okay, you can stand in front of the coordinator. Okay, court is back in session in cause number 23CCCR 1888, case of style, State of Texas versus Ryan Paul Barrett. And court previously announced that the court was placing Mr. Barrett on probation. It's 30 days probated for a period of 1 year. $300 fine plus court costs. Now, the court is going to in this case, we have community service. So the community service in this case will be 60 hours of community service. You cannot have, well, we get to that later. We have a curfew from 10 p.m. to 6 a.m. and we have no contact with Dalen Thornton. That is, the defendant shall not commit. Well, do you have the full no contact or just the second half?
Just the addition, I believe the court has a provision that he not have contact with the defendant.
In a threatening or communications with her in a threatening or harassing manner.
And I would
Correct.
suggest that we add to that
Okay,
the provision that says this order shall not prevent contact or the frequenting of places as is usual and customary in child rearing and consistent with any custody order entered by a family court.
and that's agreed upon by the state
Yeah, just looking at the language, I have no reason to disagree.
and probation.
Yes, sir.
Okay, so Okay, I'm gonna need a copy of that, but she'll need a copy of that so she can,
It has to be on the
it's gonna,
judgment?
it's gonna be on the judgment. Right, because that's the court order.
Your Honor, I would also request that the court waives a curfew. This man, the report indicated he's not into alcohol or drugs. He is a Little League coach and they frequently go to tournaments and which would require him to be out after the time the court presented. My former background, I was a PSI officer here for Jefferson County, did probation work here for 11 and a half years. I have a master's degree in social rehabilitation. This man does not need a curfew. And I would ask that the court recognize that. This thing has nothing to do with being out late at night or carousing around. He's a responsible man. He's on the Little League board for
Okay,
the Groves.
I
Little League.
understand. Now, what I can do, I think I'm gonna leave the curfew, but we can put some additional language on that because the probation officer can approve him going to the various activities. And so let's see, what was the standard language? Except for employment purposes. No, the standard language is defendant be inside his home every day. Looking in the PSI, I didn't see anything. Did it have anything about baseball?
Yeah, I don't know that.
They missed that. I didn't see that in here. That
It
he
may
was,
not have come up and
Yeah, I know.
I'm just letting the court know that he's
Okay.
active, he's got children in sports. We would want to encourage him to do things like that, be a coach, be contributing to the community in a very meaningful way. And curfew is going to hinder his ability to do that. I asked the court would waive it. What does probation office think about it?
I wasn't here for the trial.
no, I'm just saying that.
They're asking about a curfew.
It's not, this is the.
It's the state's position that it's a same condition, it's an appropriate condition for this case.
Because I think the probation department can approve him going to various functions. I get stuff from the probation department every time. He would just have to keep his probation officer informed. And then that would be the best way to do it. I don't think we're gonna just remove the curfew.
Well, I would ask the court to do that. It serves no purpose in this case, and unless the court is just wanting to be punitive to this man.
No, it's not being punitive. These are just some conditions. Now it says, it's gonna say, be inside your home every day between 10 p.m. and 6 a.m. except for employment purposes. Now, if there's some other purposes, then the probation office can approve him being outside during the curfew hours. Okay, so we're gonna keep the standard language in. Okay, now let's see, and he will also be required to adhere to the other standard terms and conditions of his probation. So this is the order of court. Just have a seat. The court coordinator would have to draft up the conditions of probation. And once those the probation are drafted up, then we'll be able to sign.
Yes, how you doing?
I'm doing fine. How you doing, Mr. Collins?
Moving along.
Well, that's
Glad to
good.
Be here.
That's good. Now, this is cause number 23 CCCR 2222, the case of style state of Texas versus James Ray Collins. Mr. Collins, how are you doing?
Mhm. I'm blessed to be here, Judge. Hey, you know what? We could complain about a lot of things, but I'm blessed to be here.
I understand. Now, Mr. Collins, you're representing the case by your attorney John Cole. Mr. Cole, how are you doing?
Great, Judge.
Okay. Now, Mr. Cole, what is your announcement in Mr. Collins' case? Reset it for trial? Okay. Give us a reset date for trial on James Ray Collins,
July 22nd.
July 22nd, 2024. Mr. Collins, your attorney is gonna get your reset. Once you get your reset, you'll be free to go. And you have a blessed day. I think the first time that you came to court, Mr. Collins, he said the weather report that it was gonna be chilly,
Yeah.
and you went outside with a bowl.
Hey, you know what? Get full. Thank you.
Yeah.
Excuse me.
Yeah, she'll give you a reset. You be excused.
Thank you, Judge.
All right, you have a blessed day. What else do we have? Did Miss who, we have any pro says?
Is Burbank still in trial?
Oh, that's right, he was in county yesterday. He may be, somebody named Brian Chance is is in the waiting room. That's Mr. Gertz. Mr. Gertz is gonna be appearing by Zoom. And Riego was reset. Who else do we have? I would imagine you need to find out if Mr. Burbank is still in trial. He was in trial in Hardin County. When was that? Monday or?
I thought it was
Yeah.
like he was selecting a jury.
Yes.
Check. Yeah, that's what I'm practicing all. Yeah.
Brent J. Thrasher. Oh, no, that's, he's in jail. He's in custody. Antonio Alfaro.
That's, Charlie Grossman's gonna allow the letter of breath on that.
Oh, that was a reset?
Yeah. He has another case, Charlie. Fracture. No.
Oh, no. Krista, that's William Wilkerson.
Did you get the reset?
Is that Krista Smith? Your attorney,
Yes.
is unable to be here for medical reasons, so your case will be reset. The court coordinator is gonna give you a reset. Once you get your reset, you're free to go. And you have a blessed day. That door is locked, ma'am. Patrol was dismissed. Sound like Jefferson County Court at law number 2 is back in session. The court is in session in cause number M326384. Case is styled the state of Texas versus Brian Chance. Mr. Chance is appearing via Zoom. Mr. Chance, you can take your mic off of mute. Mr. Chance, how are you doing?
Good, good. How are you?
I'm doing fine, thanks for asking. Mr. Chance, you are represented in your case by your attorney, Attorney Ryan Gertz. Attorney Gertz, how are you doing?
I'm good, Judge. Thank you. Good morning.
Good morning. Now I have before me a joint request for a plea and or sentencing by video conference under the Texas Code of Criminal Procedure, Article 27.18. Why this thing's not, I don't see that it's signed by the defendant. Mr. Gertz, the document that gives you and your client a right to appear via Zoom, I see your signature, I see the prosecutor's signatures, but I don't see the defendant's signature.
Yeah, Judge, I signed it on Monday, filled it out and signed it on Monday, but he wasn't present. We didn't have a hearing or anything. We were preparing for this. And so I'm not sure why we weren't able to get it to him to sign, but obviously he can orally consent to this. And this isn't a motion to revoke his probation or anything of that. It's a motion for early termination.
But you saw him earlier consenting, but the paperwork goes in our file. He should have had a signature there should be a signature on this document, excuse me. Yeah. Yeah, I think you need to. Now, is Mr. Chance?
Yes, sir.
Are you somewhere where we can maybe email this document to you? You can sign it and email it back?
Yes, sir. You can email it to me.
Okay, hold on a minute. Let me get off of YouTube so everybody in the world won't have your email address. Hold on a minute.
One way to get spam.